respect for, and as I've indicated. And I'm very concerned about his physical condition, and I hope that he'll get well soon, and I'm very concerned about it, and I've discussed that with our client. But talk about sanctions. When have you ever seen a case, Judge, where, first of all, they get up and make an unfettered opening statement to our jury because we wanted to be professional? We didn't object to the very end. It became absolutely necessary. Because of events beyond our control, I couldn't start that day. We had to leave. The jurors got to go home that night. We came back the next day, and I got my chance to make the opening statement, in which the things that I said, I expect to prove. Things that I know from my client, I don't think that they can change that or talk about leveling the playing field. Because apparently they felt the job that I did made them nervous and upset the next day. We saw these histrionics. And so they now want you to carve out some new law. They have no cases that cite this, and you have a lot of discretion, Judge. They want to carve out some new thing to give them like another opening so they can get back up and talk. Well, then do I get a chance to respond to that? I mean, that doesn't make any sense. Everything that we did, we've done in good faith. We want to try this case as much as they did. In fact, you recall I've said for the last 10 days, let's stop all this posturing. Let's get this case on the way. The final thing I want to say is this, that it's rarely productive of good to malign citizens. As you know, I'm a big fighter for jurors and for witnesses. And for Mr. Darden to stand here and say that Christian Reinhardt, was dumped by Faye Resnick is perhaps the greatest bit of hyperbole I've ever heard. That is so far from the truth. It strains credulity. It didn't happen. He put her out because she was using drugs. And after she used drugs so badly, in that 5 or 6 day period, he was the one who helped put her in a drug treatment place, Judge.
Mr. Cochran, as interesting as that conversation about that probably is and probably will be later,
Sure.
my interest is in the people's request for sanctions. They've asked me to tell the jury that I'm striking from your comments and for them to ignore your references to these various witnesses and items that they've discussed. They've asked me to admonish them that the mention of those was not appropriate because the prosecution was entitled to know of those witness statements or the identity of those witnesses before the opening statement was made, and they're asking for a 30-day continuance. So I'd like your observations on the various sanctions that the prosecution has requested.
Let me do that. Thank you, Your Honor. And the only reason I was doing about Reichardt, I just felt you have to set the record straight sometime. There's a man, he's a doctor, Judge. He's out there having these slings and arrows. We can take it, but it's not fair to these other people to go through Christopher Darden's thing. I know he loves them too, but we can take it better. Judge, with regard to the 30 days, I think, again, Your Honor, it's almost like they're kidding about 30 days. Your Honor, they haven't even called their first witness. You know, you're very optimistic, and so am I generally. I'd like to think the defense is going to start within 2 months, probably more like 3 months. Judge, by that time, they'll have time to investigate everything. They've got the LAPD, they've got the DA's office, they've got everything. Look at all this information they supposedly got on Marion Gerchas, supposedly, which apparently isn't true, but they can have all the time they want to investigate. And as Mr. Douglas says, we're not trying to play any games, and to show that, they can have as much time as they want. I don't mind if we're going to call her as a witness, calling her at whatever time you set. I mean, we would play by the rules. I don't have any problem. We made a mistake with regard to her. With regard to the other witnesses, Judge, I don't think they can show there were any mistakes. I think that they knew about Carrie Mullis. They knew, I mean, they say to me that I say that he has this man suffers from rheumatoid arthritis. Those are the facts, and I'll be able to prove that. What do we strike based upon that? They don't like the truth, and they want to try to change it around. To talking about a level playing field. So as I listened to it, I didn't see, and I try to go through the list of witnesses. I mentioned Ron Fisherman, and they know about Ron Fisherman. We hadn't turned that report over. With Chris Reichardt, they know about Chris Reichardt, Judge, because they've interviewed him. They've interviewed him. We don't have a report, I don't think, from Christian Reichardt. We don't have a report. And we don't have a report from Fisherman, so we have nothing to turn over. They know about Lenore Walker, Judge. In fact, let me respond to that on Lenore Walker. With regard to Lenore Walker, we got a special order. She went to the jail over 2 weekends. She has not finished her examination, as I indicated to the jurors. We don't have a report from her, and we don't have one from Geraldine Butch Staley either, who's their associate, because they were due to go to the jail last weekend to finish their reports. They haven't finished them, or finished the testing. So again, that's not anything. We tried to give them the CV. We've done what we could on that. With regard to Michelle Abduran, they know about Michelle Abduran. Joe Stellini, there's no report. So, Judge, the sanctions they're asking are far out of line with what should take place. I think we're in a similar position than what they were. What I'm trying to indicate to you is that we've not done anything intentionally. We would not do that. We're just trying to get what we know we can prove before this jury at the earliest possible time. This is the first time we had to do that. And so I would ask the court not to try to come back and then gut my opening statement by trying to pick out things that we said if it's the same situation. If we don't prove those things, the problem comes with that. Where does it say that because in an opening statement I make a statement believing that they have Marianne Gerchas' testimony and they don't have it, when they should have, because of the statement of itself, in that statement, if you look at it, has the DA's phone number. Marianne Gerchas says she has the DA's phone number from Patty Fairbanks, who puts her on hold, and she tells about calling all these police departments. So and this is an investigator I have never met with, and I received that report within the last couple of days before the argument. So I think that if you look at it, what I think you should do is put us in the same position that you put the prosecution in when they were faced with the same situation in December. I mean, what's fair for them is fair for us. We wouldn't ask any more or any less. It doesn't go to my opening statement. Just much of what you have seen over the last couple of days, make no mistake about it, is to try to keep me from getting back up before that jury. There is an ultimate sanction today. Now, I believe that Bill Hodgman is sick, but everything that's happened, when Mr. Darden kept talking and saying the same thing 6 or 7 times, I thought he was filibustering, and obviously it was so I couldn't talk to this jury today. But ultimately, Judge, no matter what they do, I get to finish talking to this jury. That's not a sanction they can impose. I get to get back up there. They're not going to like that. And so that's what this is about. And so I'd ask you to be fair in that, and be fair like I thought you were imposing to them. If we slipped up, I'm telling you it was not intentional. We would not do that. And if we slipped up, the same sanctions they got in December should pertain to us. And if that happens, it has nothing to do with the opening statement. I haven't misled anybody. If Christian Reichardt...
Well, the problem is I can't really impose the same sanction at this point, because part of the sanction was I told them they could not use certain witnesses in their case in chief until they had completed their original witness list, and they could not mention it in opening statement, which, as far as Mr. Darden is concerned, I essentially took the heart out of his domestic violence argument, because he was not able to mention 3 or 4 other incidents that fill in certain time gaps. I assume that's the argument he's about to jump up and make.
Well, when you say take the heart out of it,
Well, that's his argument.
Okay, well, yes,
I'm asking you to respond
yes,
to that.
well, I will. I think that, Your Honor, with regard
So
to
I
that...
can't give you, or I can't impose upon you the same sanction.
Well, you can give... I think the thrust of it, though, Judge, isn't it that they would have an opportunity to try and check these things out? I mean, I think, for instance, Christian Reichardt, they already know about him. We don't have a report, so that's maybe a bad example. They know about him, they already have a report, and maybe that's a bad example. I mean, the only one that I can really fix on, because they know about Ron Fisherman, is Marianne Gerchas. And I'm just saying to Your Honor that in 24 hours, they've done all this work supposedly on the rest of the people, Judge, they knew about, and we don't have any reports on them. So I don't know where we go from there to saying, admonishing this jury regarding this. You admonished them, even after I didn't get a chance to talk to them for a whole evening. When they came in yesterday, you start off by saying, what counsel says is not evidence. And that's exactly what it is. It's not evidence. So, you know, we're going to have evidence. The case will ultimately be, why are they so afraid? The case will ultimately be decided. We want to uphold all the rules like everyone else. But why are they so worried about that, Judge? Ultimately, it's going to be the evidence that this case is decided upon. And that's all that I wanted us to get back to. The rest of these witnesses, and some of them, is that they knew about them. We don't have any reports, with the exception of Marianne Gerchas, that I can see as I look at the list. And I think that the sanctions are way out of line with where we are. And having understood what your sanctions were back then, we have to deal with where we are at this point. With regard to Marianne Gerchas, this is a witness who gave a statement. I don't know her. I have a statement from her. The investigators talked to her. And that's how it came to me. assumed they had it, and I wasn't aware they didn't. And again, I apologize for that. But I don't think that's any reason that Mr. Simpson should have to suffer, where these jurors would have to be told, oh, gee, it's not evidence, but just disregard that. It's not evidence. And, you know, and Judge, if we do it based upon that, I could come back tomorrow and say to you, Judge, I want to look at the transcript. For all the times Ms. Clark was argumentative that I didn't object because as an officer of this court and a gentleman, I didn't want to do that. That's like running back, doing something like that. I don't want to do that. I want to get this trial on. I want to finish my opening statement so they can call their first witnesses. And so what I'm going to ask you to do is to fashion something that's reasonable. You're wise, and in these situations, it calls for a wise decision. Well, we have done something in good faith, and I will conclude by saying this, Judge. We certainly don't refer to ourselves as a dream team. Just a collection of lawyers who try and do the best we can for our client. And that's all we're doing. And others can refer, Mr. Darden can refer to us derisively or any way he wants to. But we're just trying to do our job. And in that, Judge, we're trying to represent our client to the best of our ability. I think you know, we would never intentionally mislead this court. We would not do that. I would not do that. I know that my reputation means far too much to me. And this case is not the last case of my career. And so we don't have the obsession that some seem to have about this case. We want to try this case. We think we're going to win this case. But we're not out here trying to win this case at all costs. We're trying to do it methodically and do the job that we're paid to do. And that's what we expect to do, ethically and morally, Your Honor. And all I ask you to do is to allow us, remember that part of the sanctions have already been the delays, the internal delays in my opening statement getting back to that jury. Allow me to get back to that jury without any real unnecessary delay. If the court felt that there was some problem with regard to Bill Hodgman, obviously we want to listen to that. I mean, that's something that I am sensitive to, and I've talked to Mr. Simpson about that. Although he wants to proceed as fast as he can. I'm sensitive to that. But with regard to these other things, Judge, when you look at when it's reduced down, you know, things that I knew because my client told me, I don't have an obligation to that. And I hope I put the envelope and the other things in perspective. So I'd answer any other questions that Your Honor has for me at this point.
Well, you're objecting to the 30-day continuance that Mr. Darden has suggested.
Yes, Your Honor, I think that is far, far too long. What are you going to do for 30 days? Judge, we have a jury that's being sequestered. They've wasted another whole day today. I don't have to tell you that, but those are the facts.
All right. Thank you, counsel. All right, Ms. Clark, briefly, please. And let me ask you a couple of questions before we launch into this. Do you concede that Dr. Mullis was on the DNA list for the defense for the DNA?
Yes, I do. He was on the Kelly Fry list. And
Yep.
his deletion in the trial list led us to believe that he was not going to be called at trial. And that is the problem that is posed, is that we were just beginning to prepare for the Kelly Fry, and then matters were transpiring at a rapid pace. We ceased preparation when it appeared that there was not going to be a Kelly Fry hearing. And that is the problem with him, but it's not nearly as egregious as the others, because we did have some notice of his existence for the defense. Let me indicate to the court that with respect to the 30 days, I believe it was the defense who indicated, and at the court's request prior to this, when they wanted time to investigate witnesses that they claimed they were given late notice of, although they got them far in advance of the last hour of opening statement, they asked for 6 weeks. They thought that was a reasonable time for investigation, as did the court. We're asking for less, even though we would be, under a parity of reasoning, entitled to the same amount of time for reasonable investigation. We are not obsessed with this case, Your Honor, but I wonder about the defense obsession, because their desperate tactics in throwing ethics out the window and behaving as they have is evidence of clearly the opposite of wanting the fairness and justice that we're entitled to in this case. There should be no mistake about it. This conduct should not be minimized this way. Mr. Cochran's very persuasive, very talented, very charismatic, but I'm sorry, Your Honor, in this case, he is wrong. He has done wrong. This is not the way to behave. This is not ethical conduct or behavior. And as I told the court, he glibly stands up to say, well, the people can address it all in closing argument. No, no. See, it's too late. Because by then, Your Honor, there have been months of time for whatever that jury has picked up that will never be addressed in trial, those witnesses that Mr. Cochran referred to that may never be called out of some kind of fear that he's thinking of, or witnesses that never appear at all, that after they've been represented in front of this jury, they will have that witness in the back of their mind, and that may be enough to persuade the one. Any kind of relief that the court grants us at this point may still not be enough, because the damage may be indelible at this point, after him having mentioned all these people that he himself knows is in danger of not ultimately being called, because once they're investigated, it's determined they have records, they have felony records. These are people that really will not withstand the scrutiny. They know it. The defense knows it. And the willfulness of their tactics in delaying the discovery is shown by virtue of one simple fact. Early on in these proceedings, the defense floated up the name of Frank Churchill from Happy Camp. This was a man who came forward to say that he saw burglars, 2 white burglars, leaving the home of Nicole Brown. It was then discovered that he'd come forward to offer false information on other famous cases, and his credibility was exploded as it deserved to be. And the defense realized that then they're going to have to hide their witnesses to prevent the exposure that would show them to be as incredible as they are. And that's what they've done in this case. So it's a very willful thing, and it's not a minor thing. This is a major form of misconduct that has occurred, and I don't want Mr. Cochran to minimize it this way. It is major. And if we look at, let me just contrast it for a moment, because I know what the court is going to say. Okay? Their statements were taken 4 or 5. I saw it.
How am I going to rule?
No. What? I'm sorry.
Never mind.
The counsel wants to compare the gravity of their misconduct to what occurred with the people, and let me contrast the two. The statements turned over by the people were 2 and 3 weeks late. The statements turned over by the defense were 4, 5, and even 7 months late. We were sanctioned for that for just 2 or 3 weeks, and now they're fighting the sanction for 4, 5, and even 7 months for material witnesses. Obviously, witnesses they think are very important because Mr. Cochran is outlining their testimony to the jury. And when you also look at it in this context, Your Honor, out of the tens of thousands of pages that we've turned over, dozens of videotapes, dozens of audio tapes, we were slow to turn over by that I mean 2 to 3 weeks, a few pages of discovery compared to what they did. We had 70 pages of discovery, Your Honor, until the last 2 or 3 days. Now they have doubled the amount of discovery in the last 2 or 3 days. What that shows this court is not only that the gravity is very severe, that the misconduct is very serious, but that it is not inadvertent and cannot be claimed to be. You don't overlook over half your case. And that's what they claim to be doing. I don't believe it. I don't believe it. Mr. Cochran is an excellent lawyer. He knows what he intends to use. He knew what he intended to tell this jury. His statement was typed and it was prepared. And he cannot come before this court and tell us that he didn't know about these witnesses before or was unaware of their statements. And the fact that Mr. Jones Mr. Douglas can stand up before this court and say and try to excuse the misconduct by saying, well, this wasn't always the law, it makes it even more egregious, because what he's indicating is a desire to thwart the law, a desire based on his own belief about what he should be able to do as defense counsel. Unfortunately, the voters of this state have spoken. They have said, we will not countenance any more of this hide-the-ball stuff, this shell game in the course of a criminal trial. We want it to be a real search for the truth. We want both sides to air their witnesses so that everybody can have full and complete investigation. And that is the problem with what defense counsel has done. They are trying to prevent us from doing our job. I want Mr. Cochran to get up and speak to this jury as long as he wants to. I don't want to stop him from talking. I want this opening statement to get going and to get completed. I want him to be able to put on every witness he desires. All I ask is the ability for the people to investigate these witnesses so that the jury gets the whole truth, so that we have an opportunity to show the jury who these people really are. And when these people are hidden from our investigators, we cannot let the jury does not get the true picture of who they really are. I would not be doing my job if defense counsel were permitted to trot a parade of witnesses up to that witness stand and I were to sit back and say, what's your name? What time is it today? Thank you very much. I should be fired for that. It's our job to search for the truth, and it's our job to show this jury the real credibility of who these people are, what these witnesses really is. And if this jury doesn't get to see that, they're deprived of the truth. And if they're deprived of the truth, the people of this state are deprived of justice, and I cannot allow that. That is not my job. My job as a representative of the people is to see that that does not happen, that any witness who is called is given thorough and complete examination. And what they are attempting to do here is prevent that. Marianne Gerchas now claims that she called our office. This is not a woman whose credibility is unsullied. And if she did call the office, which counsel knows because counsel had the same problem, we've all gotten thousands of calls from every Tom, Dick, and Harry that wants to get involved in this case. If the person doesn't pursue it, sometimes they don't get reached again. But I think it's very interesting that they say that. What, are we supposed to now say that the lawyers can rely on the witnesses to give discovery? Is that what he's saying? She's supposed to give her discovery to us? I mean, somehow he's putting the obligation on her to come forward. No. The obligation is not on the witnesses to turn their statements in. The obligation is not on the DA's office to go begging for the defense witnesses to come and talk to us. The obligation is for the defense to give us what they've got, the same as it is for us to give them what we've got, and we have done so diligently at every bend and turn. We have not attempted to avoid it in any way. Now, I think that what the court should know is that Mr. Douglas's position vis-a-vis the law, vis-a-vis his requirements in terms of turning over discovery, taking reports, and reducing statements to writing is wrong, 100% wrong. It's so wrong that previous courts have found that conduct to be contemptuous. I cite the court to the case of In Re Serra, S-E-R-R-A, 484, Fed 2nd, 947. The court held that a defense attorney should be held in contempt for asking an expert to refrain from writing a report in order to avoid discovery. Also cite the court to Standeffer versus Superior Court, 18 Cal. 4th, 672. It cautioned again the attorney not to direct an expert to avoid writing a report in order to avoid discovery. Counsel has deliberately done an end run around the discovery laws, basically by trying to get their discovery from the mouth of their client. Here, Mr. Simpson, go call Ron Fisherman, tell us what he'll say. And then they go and ask Mr. Simpson. I mean, that's a very clever game, but it certainly does not serve the ends of justice, and it does not comport with the spirit and the letter of the law under 1054. We love the fact that they have Henry Lee for an expert. But if he's such a great expert, he's so well renowned, and I understand he is, how could he not have written a report with respect to all of the work that counsel has told us he's performed in this case and will testify to here? No report. He's been on the case since day one. We're all aware of that. And to tell us now that he has no report to offer us, that Dr. Bowden has no report to offer us, that Sylvia Wolf has no report to offer us, this is unbelievable. You know, this conduct cannot be minimized, should not be minimized. We have been placed in it's a very unfair position that we are placed in. I think that the goal of a trial is for the truth to emerge, and it's not for a lawyer to hold in his head information that he or she may use to ambush the case with. And that's what we have here. It's a trial by ambush. That's the strategy. The people would request, number one, that the court admonish the jury with respect to counsel's misconduct, as I've indicated earlier. Number two, if the court is not inclined to strike the comments, the offensive comments by Mr. Cochran, and let me indicate about that envelope, he waved it in front of that jury and every single one of them saw it. And we all know that after the preliminary hearing with what occurred there, everybody knows about the envelope. Everyone on the jury said so. Mr. Cochran knew what he was doing. That jury saw what he was doing, and that was a setup, as sure as I'm standing here, because he knew that he was going to surprise us with that, a surprise tactic, that we would object, and that the jury would then see the objection and maybe conclude that we were trying to hide evidence, when in fact what has happened is we've been hidden from. We don't know what's in the envelope. We haven't seen the reports. Counsel knows better than we do. They know what they're waving around. We don't even know. All we're asking is let us know. We want to know. We want to know what their witnesses have to say. We want to know what the evidence is. Is that asking so much? Under 1054, it's not asking anything that we're not entitled to. That's all we ask for. And under 1054, there are a certain number of sanctions that are allowed under the law, and Mr. Cochran is aware of that. And if the court is not inclined to strike the offensive comments, then the people would request that we be allowed to reopen to address those matters, but that's in conjunction with the admonition, and that after the conclusion of opening statement, that we be permitted a continuance in order to investigate all of these witnesses that were just recently thrown at us at the conclusion of Mr. Cochran's opening statement remarks yesterday. I think it's only the alternatives that I oppose to the court, I think, are the only way that the people can be made whole. We are not being hysterical here. We are simply asking for an opportunity to do our job. That's all we're asking.
How would I justify granting you a 30-day continuance if we all agree the people's case in chief is probably going to take between 2 and 3 months to present? Doesn't that give you adequate time to go out and prepare to rebut or to impeach these witnesses, these 12 or 14 witnesses who've just been disclosed?
Well, we're tied up in trial. We can't get involved in the investigation. That's the same game that's been played throughout this case. We're tied up in court with days and days of jury selection. We have to be out there too. We can't just send people out to do things for us without guidance. Yes. I don't think that the people's case is going to take 2 or 3 months. Not even close.
Promise?
Yeah, I mean, I'd like to, but I really don't think it's going to take that long, Your Honor, seriously. I think that the people's case might well be wrapped up in 4 to 6 weeks.
All right, do you have any other comment?
If the court would like, I think I have other case authority concerning the ability of the court to grant us the reopening of the statement.
Well, that's kind of an esoteric question. I think there are two other cases that I've been able to find in Lexis, but in other states.
I have a California case.
All right. Let me ask you another question. That's really an esoteric issue about reopening. What kind of,
This case is right on point.
well, as after an abuse of discovery, it's right on point, reopening?
It's not to address abuse of discovery, it's to address something else, but it does indicate that it would have been reversible error to deny the ability to reopen the opening statement.
Ooh. Thing a trial court never wants to hear about. All right, Ms. Clark, let me ask you this, though. What kind of admonition would be appropriate here?
I think I indicated earlier what
No,
my
I'm talking
request was.
specifics, words.
Didn't I? Oh.
Just to pick out each one of these individual things and tell them disregard these comments? To say during the course of the opening statement by the defense counsel, this witness was listed, this person was mentioned, this person, disregard all that? Is that what you're asking me to do?
There would have to be,
And then say the reason for this is because we have rules of discovery, that is disclosure of witnesses, because they weren't disclosed and it was a surprise to the prosecution, they don't get to talk about it in their opening statement. And that's the reason for the delay. Is that what you're asking me to do?
I would like, may I have a moment, Your Honor? We have to,
Well, I
We
mean,
haven't had
you're asking me to do things.
Right.
I want to know specifics. What are you asking me to do?
if the court would like me to actually frame the language of the admonition, I would be happy to do that. If the court could give us, well, it's kind of late already.
All right, well, before you answer that question, let me ask you the question that's more pressing on my mind, is what is the condition of Mr. Hodgman this afternoon?
We don't have final word, and we will not have final word as to when he's going to be available to come back. We won't have that today.
Do we have any idea when he's going to be released? I saw Colleen Williams reporting a press conference down at the hospital.
Yeah, I believe the doctors held a press conference, but I have no idea. What the people would request is that the jury be admonished as follows: that defense counsel has committed serious acts of misconduct, that they are to view very carefully the opening statements, they are not evidence, and that to the extent that they fail to fulfill the promises made in an opening statement, any statements made should be disregarded because they do not constitute evidence.
Then
They should be-
that invites them to speculate that the whole thing is bad.
That what whole thing?
Don't I have to be more specific than that? Because certainly not all of Mr. Cochran's opening statement is in dispute, or the propriety of it.
Well, Your Honor, we're going to have to take a break so I can frame then something more specific. I can't at this time, but they do need to be admonished concerning counsel's misconduct. They need to be admonished to disregard counsel's statement concerning the witnesses who will not appear out of fear. That was a totally inappropriate comment, very improper, and the jury very prejudicial. The jurors should be admonished to totally disregard that. There's no evidence to that effect. And then we should ask counsel at this time.
Mr. Cochran, I'm aware of your 1335 request, so.
We're
That's fine.
entitled. We can litigate that later.
As soon as I receive a motion and application.
We also would request that the defense sit down with Mr. Cochran and review the balance of his opening statement to determine if there are any more witnesses he intends to mention that they've somehow magically forgotten to give us discovery of. We would also request that the court order them to reduce to writing all of these reports they carry around in their head with respect to the witnesses that are civilian as well as the experts who they intend to call. And we have no problem with the resumption of opening statement, provided it begins with the court's admonition to them.
Do you want Mr. Hodgman to be here?
I would definitely prefer that Mr. Hodgman be here, Your Honor. And I'm going to have to find out how long it's going to be. I don't know.
All right.
I feel like it's unfair of me to make a request to wait for his return if I don't know what that is, and so I'm going to have to ask leave of the court to get further information before I make any request along those lines, either way. I mean, if he doesn't come back for 2 weeks, is that fair? That's not fair to defense, and so I should really find out how long we're talking about before I ask for anything.
Mr. Cochran, you have a plaintive look on your face.
Yes, it's not like a plaintiff will, but it seems like the press is being, like a plaintiff will. The press is being told about Mr. Hodgman's condition through press conferences and things, and why don't they take a break, and then they can call and find out?
Because the press isn't being told when he's going to be released.
But I think they should make an effort to try to find out.
Well,
All
we
right.
will.
All right, well, why don't you take 5 minutes? My court reporter tells me she's out of paper, so let's take 5 minutes. Why don't you make a phone call upstairs? And this is not a recess, so everybody stay in place.
I have asked to be beeped as soon as they find out. So
We don't turn on beepers in the courtroom, do we?
But my beeper isn't with me, so it's okay. My beeper's upstairs. They're going to call me. So I'm supposed to get a call the minute they find out.
All right, Ms. Robertson, what information did you receive from the ever-present Ms. Fairbanks? Mrs. Robertson, you'll need to speak up.
She indicated that it was healthy and his doctors anticipate he will be released sometime next week, that if he made his wife requesting that he have an additional time off period. Basically, that was Fairbanks related.
So he's going to remain in the hospital till next week?
Basically, that's what he said.
See, I had asked that as soon as we had knowledge that we'd be called, and they did. Thank you, guys. So that's all we know right now, is that he'll be back sometime next week, at least released, but we don't know when he'll come back yet. That might be.
All right, in light of that, Madam Reporter, have you changed your paper? Yes, sir. Ms. Clark.
First of all, Ms. Fairbanks asked me to inform you that the ever-present Ms. Fairbanks is here. She's gotten word from the press conference that they will not state exactly when Mr. Hodgman is going to be released. The doctors would not give a definite date. And as for his return, it's uncertain as to whether it will be the beginning part of next week or the end of next week.
All right, in light of Mr. Hodgman's absence, when will you be prepared to go forward in his absence? Can you be prepared tomorrow to go forward?
With opening statements or with evidence? Opening
The
statements.
whole enchilada. I assume Mr. Cochran he indicated he had one other segment of the case that he wanted to talk about. And I assume, although that'll be a rather large part, I assume it's not the whole day. So I would assume that he would conclude his opening statement in the morning and that we would proceed to witnesses in the afternoon, assuming we started at a normal hour.
I mean, the court has not indicated any ruling so far on the people's request for a continuance to deal with the discovery that was just dumped on us over the past couple of days.
I'm asking you, when will you be able to do that? I'm mindful of Mr. Hodgman's absence. I'm mindful of the fact that he is a critical member of the prosecution team. I frankly will need time to go through my notes, prepare the record, because we were talking about, as I indicated, my recollection is we talked about 26 specific items of discovery and/or witnesses, so this is not something I feel comfortable ruling from the bench upon. So I probably will not be prepared to rule upon your request and for sanctions until probably late tomorrow is my problem. And I don't know that I want to drag the jury down to sit around and wait all day again. I don't know the answer to your question.
What we could do is there's a possibility that Mr. Hodgman will return on Monday. If, for the purpose of having him present for opening statement, we could do that on Monday. But then, what I thought we could do is sever the issues of the opening statement being completed and then the
Well-
request for continuance.
You dumped a rather large number of things in my lap. It also is going to require me to go back through and read Mr. Cochran's opening statement again to go through the record to see what's mentioned and where. So this is not something I'm going to be able to accomplish between now and 5 o'clock.
No. And, Your Honor, this is from the defense. This is not from the people. But,
Your request, though.
well, it is our request,
All right.
necessitated by. Anyway, why not start it, if we could have it go over to Monday for the purpose of completing opening statements. And at the conclusion of opening statements, would that give the court time to rule on the people's requests? And that way we would know where we stand.
All right. Let me just ask Mr. Cochran one question. All right, I'm contemplating going over to Monday. That'll give me time to review this, make my ruling, and we can find out definitively when Mr. Hodgman will be back. My inclination, though, is to direct the people to be ready to proceed if I rule that certain sanctions are appropriate, but that we're going to conclude the opening statements, that you be ready to proceed immediately, Mr. Cochran. And assuming that we proceed on Monday, that the prosecution also be ready to call witnesses Monday afternoon.
I'll be ready. I'm ready now, Your Honor.
I understand that. I'm ready, too.
I know. That'll be fine. I'm ready, and make no mistake, it's the people's motion, not ours, and we don't agree with it. The one thing I'd like to say, Your Honor, however, with
Well, the
regard-
situation is, the creation of the situation, though, I think rests on this side of the table, as Mr. Douglas conceded that these statements should have been disclosed, so.
I'm not trying to- we've said that, we just said that it was inadvertent. The point is, Your Honor.
No, and I compliment Mr. Douglas for being upfront, saying we should have done this.
That's the kind of lawyer that he is, Your Honor, and we'd like to see that on
But
the
it's
other
the
side.
creation of the problem.
Your Honor, what I'd like to say is this, though. I would like to suggest to the court that I'd rather not have Marcia Clark drafting. I'd like for you to
No,
have that. I'd like
counsel.
to have that additional time. I'd rather not have her drafting anything that relates to us.
What I'm going to suggest is both sides submit by 10 o'clock tomorrow morning any admonition to the jury they feel is appropriate.
All right, thank you. I think that's fair.
All right.
Thank you. I think
All right,
that's
we'll
fair.
stand in
We'll be
recess.
ready on Monday?
9 a.m. Monday. Be prepared to go. Thank you, counsel. 10 a.m.